The next bill on the calendar for the day is Senate File 4760. The Chief Clerk will report the bill.
Senate File number 4760, an act relating to public safety, the second engrossment.
Before the author explains the bill, we have an amendment at the desk to insert the House language into the Senate file. The Chief Clerk will report the amendment. Oh, boy.
He moves to amend Senate File number 4760, the second engrossment. The amendment is coded DEA 3990.
I recognize a member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker. That is my motion, and I recommend a green vote.
Discussion. Seeing none, all those in favor of the amendment, please signify by saying aye. Any opposed, say nay. The motion prevails. The amendment is adopted. I recognize a member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker. House File 3990 is a public safety package. It contains 16 bills that have already been 16 bills. 13 of those bills have already passed off this floor, standalone bills. The bills that the House have passed are part of this bill. 2169 from Representative Schwartz, a bill about allowing protective orders from Canada be recognized under Minnesota's second-degree unintentional murder status. House File 2358, Representative Van Spinbergen's bill on increasing penalties for sextortion cases. House File 3155, Representative Tabsky's bill that adds gift card fraud to organized retail crime statutes. House File 3453, Representative Hansen's bill that increases the age to 21 for the legal possession of kratom. House File 3496, Representative Harder's bill that requires offenders who are able to pay court-ordered restitution to make those efforts before they are released. House File 3768, Representative Curran's bill that makes changes to the Department of Corrections licensing of juvenile detention facilities. House File 3769, also Representative Curran's bill that updates the Department of Corrections substance abuse care and mental health status. House File 3771, Representative Pete Johnson's bill that gives extra 2 weeks to the Department of Public Safety to report the legislation on the Disaster Assistance Contingency Account. House File 3782, Chair Moeller's bill that requires disclosure of chemical irritants discharged in buildings. House File 3825, Representative Rapinski's bill that makes changes to victims' rights requested by the Office of Justice Programs. House File 3826, which is Representative Whitty's bill that makes changes to the Department of Public Safety fraud and finance crime sections that the BCA requested. House File 3827, Representative Duran's bill that makes technical changes to the BCA statutes. House File 4151, Representative Whitty's private detective board that we will pass in a little bit. In addition, or I guess we just passed it. In addition, there have been 3 other provisions that have not been heard on the floor yet. Mr. Speaker, I'd like to yield the floor to Representative Curran, who will talk about House File 3870, a bill that updates the Department of Public Safety data and terminology.
I recognize the member from Ramsey, Representative Curran.
Thank you, Speaker. Thank you so much, Chair Novotny. Yes, House File 3870 was heard in the Judiciary Committee. Thank you so much for that, Chair Scott, for giving us time to go through that and work together on it. I really appreciate that. House File 3870 comes from the Department of Public Safety for the Office of Justice Programs. When OJP collects, analyzes, and distributes crime and justice-related data, currently they are not, they don't fall under a classification process. So what this bill does, or what this provision of the package would do, is protects that research data on individuals. It also clarifies that data collected from families and victims through the work of the Missing and Murdered Black and Women and Girls Office and the Missing and Murdered Indigenous Relatives Office, that any research that they collect, that data would also be private. Finally, this section removes outdated language in statute that relates to victim survivors of abuse. And again, thank you, Chair Scott and Liebling, for giving time in Judiciary, and I appreciate Chairs Novotny and Moeller for carrying this in the bill today. Thank you.
Recognize the member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker. The underlying bill of this package is my bill 3990. A recent Court of Appeals decision interpreted the Criminal Offender Rehabilitation Act to mean that if a job applicant can produce certain documents outlined in this statute, has sufficient rehabilitation that is established, and that the public employer does not have any discretion to disqualify an applicant whose conviction directly relates to that position. In this case, an applicant was disqualified from Minute for an IT position within the Department of Education after a criminal background check showed a conviction for the possession of child pornography. The Court of Appeals held that once the applicant provides the documentation listed in statute, the applicant has satisfied the statutorily defined means of demonstrating rehabilitation and cannot be qualified from employment. House File 3990 would restore the balance between the second chances and allowing public employers the discretion to make hiring decisions based on specific duties, responsibilities, and the applicant's fitness to perform those duties of that position. Madam Speaker, I would also like now to yield the floor to Chair Moeller. Mr. Speaker, would like to yield the floor to Chair Moeller to talk about her House File 3946, a bill that modifies domestic abuse cases and reporting, and would make any other opening remarks she would like to make.
Recognize the member from Ramsey, Representative Moeller.
Thank you, Mr. Speaker, and thank you, Chair Novotny, for your work on this bill, and to the committee. I am really proud of the bill that we put together, and also that many of you have seen so many of these provisions as they have passed off the floor as standalone bills. I did want to spend a minute, as Chair Novotny mentioned, to talk about House File 3946, which is a part of this, and this is a domestic violence bill that I worked on over the interim. I had the opportunity to meet Jana Williams, whose niece Allison was murdered in Minneapolis, and she was a victim of domestic assault. The case was handled horribly. There are still audits and ongoing investigation in that case, but talking to her and reading so many stories lately of women, mostly, who have been killed, or bystanders who have been killed in the course of domestic abuse, really had me take a hard look at some of the statutes, meet with a lot of different stakeholders, and figure out how can we make a difference this session. And I do want to thank Chair Rarick and Chair Scott for your collaboration on these issues over the years as well. We've done some really important work in the past and even this year on some other bills. So what this bill does, members, it includes some reporting provisions right now for officers who are, right now for law enforcement investigations involving use of force. We want to know which of those resulted as a result of domestic violence. They started out as domestic violence cases. We also want to get some more data on domestic violence cases and how those are being reported, how they're being responded to, who are the parties involved. We just really don't collect good data on that right now. And one of the most important pieces of this is changing the gone on arrival situation. So right now in misdemeanor cases, arrests can only be made within 72 hours. And what I've heard from victims and those who work a lot on these cases is that it's all too easy for an offender to be able to hide out for those 72 hours, and then nothing ever happens to that case, and then the offender comes back. And so we have put a time frame on that. It's 28 days in this bill. I think in negotiations it's going to end up being 14 days, but at least that gives more time to effectuate that arrest. And then we also have some provisions in here for when somebody is arrested and taken to the jail, what factors should be considered before that person is just released before seeing a judge, or even when they are in front of a judge, what are some additional factors in these domestic violence cases that can be considered? There was a recent homicide where the judge apparently did not read the order for protection that the victim wrote about the increasing threats to her life. And so we think it's important that either law enforcement, judges, whoever's making these decisions, have the full picture in front of them so that they can make sure that victims are kept safe. Thank you, Mr. Chair.
There are amendments at the desk. The chief clerk will report the amendment.
Novotny moves to amend Senate File Number 4760, the second engrossment, as amended. The amendment is coded A5.
I recognize the member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker. The amendment is, simply inserts the House language into the bill that came from the Senate.
Any further discussion?
Mr. Speaker, I'd like to say that A5 changes the effective date for the reasonable discretion for public employers to do their enactment. That is a request that came from MMB as related to this, and the sooner we can get this enacted into a law, there might be a court case dismissed. So I recommend a green vote.
I recognize the member from Ramsey, Representative Moeller.
Thank you, Mr. Speaker. I recommend a green vote as well.
Any further discussion to the amendment? All those in favor, please signify by saying aye. Any opposed, say nay. The motion prevails. The amendment is adopted. There are amendments at the desk. The chief clerk will report the amendment.
Lee F. moves to amend Senate File Number 4760, the second engrossment, as amended. The amendment is coded A7.
I recognize the member from Hennepin, Representative Lee F.
Thank you, Mr. Speaker, and thank you, Chair Novotny and Chair Moeller, for your staff in helping me prepare the A7 amendment. So the A7 amendment is from House File 4371. I carry on behalf of the Office of the Legislative Auditor. This is just to allow for the OLA to request the BCA to conduct fingerprints for them, and when they request information regarding federal tax information, this requirement is a new rule that's required from the federal government, and so I hope you support this amendment. Thank you.
I recognize the member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker, and thank you, Representative Lee, for bringing this forward. This is an important bill that helps the OLA get their work done and is in compliance with federal law. I recommend a green.
Any further discussion to the amendment? Seeing none, all those in favor of the amendment, please signify by saying aye. Any opposed, say nay. The motion prevails. The amendment is adopted. There are amendments at the desk. The chief clerk will report the amendment.
Whitty moves to amend Senate File Number 4760, the second engrossment, as amended. The amendment is coded A8.
I recognize the member from Dakota, Representative Whitty.
Thank you, Mr. Speaker. First, I want to start off by saying thank you to Representative Jessica Hansen for bringing this bill last year and in looking after our persons that are detained in jail and providing medications. After significant collaboration with community stakeholders, the Minnesota Sheriff's Association and Department of Corrections have found clarifying language to hopefully strengthen this bill. The amendment meets the operational realities of jail facilities while ensuring essential medical safeguards for those in custody. It is important to note the partnership between the sheriffs, community stakeholders, and the Department of Corrections on this amendment. It clarifies implementation, ensures safe medical services that protect the lives of our incarcerated individuals. I ask for your support. Thank you.
I recognize the member from Dakota, Representative Hansen J.
Thank you, Speaker, and thank you, Representative Whitty, for working on this, and especially thank you to Chair Moeller for really leading the charge on making sure we get this right this year. This was worked on between the Sheriff's Association and the advocates, and they have agreed on this. I had worked really hard on this last year, and my support this year was contingent on getting the support of all of the folks who joined me last year, including the families of folks who have unfortunately lost their lives or become permanently disabled without this law in place. So I just want to encourage a green vote today, and thank you again to Chair Moeller for really pushing this forward. Thank you.
Any further discussion to the amendment? All those in, oh, I recognize a member from Ramsey, Representative Moeller.
Thank you, Mr. Chair, and I want to thank Representative Whitty for carrying this. I just want to say when members voted for this bill last year, it had overwhelming support, and unbeknownst to us, we were met with a lot of opposition after the fact, and instead of coming to us for a solution, unfortunately, one of the private companies started a lawsuit that the sheriffs joined on to, which was really rather unfortunate. And in fact, I think it made things delay even farther for getting changed. So in spite of all of that, I'm really glad all the stakeholders were able to work this out. And as often happens here, we often have bills that we pass that we need to make some changes on in the next year. It doesn't mean we think we did anything wrong the first time we passed it, but we needed that clarity. And so again, recommend a yes vote. Thanks.
Any further discussion of the amendment? Seeing none, all those in favor of the amendment, please signify by saying aye. Any opposed, say nay. The motion prevails. The amendment is adopted. There's an amendment at the desk. The chief clerk will report the amendment.
Durant moves to amend Senate File Number 4760, the second Grossman as amended. The amendment is coded A3.
I recognize a member from Beltrami, Representative Duran.
Thank you, Mr. Speaker. This is a pretty simple amendment here. It actually keeps the age of delinquency at the way it is right now. This was brought to me by some of the stakeholders involved, and by now you guys should have gotten and received multiple packets on your desk. And the first page, you're actually going to looking at the Minnesota Juvenile Justice Advisory Committee. So they're the ones that we actually formed to actually create a format for us to follow in regards to this type of behavior. They are actually wanting this amendment to go today. So in multiple other people inside here, just to go along with the Minnesota Association of Minnesota Counties, Minnesota County Attorneys Association, Minnesota Association of County Social Services, Minnesota Inter-County Association, Minnesota Associations of Community Corrections Administrators, Minnesota Corrections Associations, and so on. We have in here MPPOA, LELS, Sheriff's Office, Chiefs of Police, and we also have a letter from the American Indian Child Welfare Advisory Council, all in support of this amendment. It's pretty simple, guys. We're going to listen. I am listening to the stakeholders here, to the people who actually deal with this on a day-to-day basis, and we think that we are not ready right now for this to go into place. We do not, as the state of Minnesota, have the infrastructure to handle this. It does not mean that we're opposed to this. We just don't have the infrastructure right now to support this change. This is something that we need to slow down. Let's make a good, conscious effort in creating a foundation that we can be successful in this area. At that, I will ask for your support.
I recognize a member from Ramsey, Representative Feist.
Thank you, Mr. Speaker, and I would like a roll call, please.
Seeing 15 hands, there will be a roll call. Representative Feist.
Thank you so much. I rise to encourage members to vote no on this amendment. You have received a letter from a large number of stakeholders as well opposing this amendment, including the Legal Rights Center, the American Civil Liberties Union of Minnesota, Legal Aid, as well as NAMI Minnesota and many other organizations. In 2024, we passed legislation to raise the age of delinquency effective this year because of significant challenges at the intersection of child welfare and juvenile justice. Specifically, because children ages 10, 11, and 12 are not competent to stand trial, they can't receive court-ordered interventions through the delinquency system. Further, interventions available through CHIPS are delayed many months due to competency hearings. As a result, critical time that could have been spent providing services and interventions is instead spent by a court weighing whether these children can understand complicated concepts like constitutional rights, plea bargains, and burden of proof. In nearly all cases, these children are found unable to understand these concepts and make informed decisions about their cases, and therefore, they can't receive court-ordered interventions through the delinquency system, and they cannot be held in juvenile detention facilities. For this reason, we need to take this make this important transition as planned in 2024 so that we can more promptly and effectively intervene when 10, 11, and 12-year-olds cause harm and require urgent interventions. For these reasons, please vote no.
I recognize a member from Clay, Representative Keeler.
Thank you. I want to tell a little bit more of this story. I sit on Human Services, and I know that there's always like a Department of Corrections or public safety conversation about this. One of the things we've been working on in Clay County for a very long time is a psychiatric residential treatment facility. And I just want to talk about why that is so important in this conversation, because we know at any point in time, if you've been connected to any juvenile detention centers, you can ask. I've asked my county multiple times, and at any point in time, where anywhere from 40 to 60% of the children who are in the juvenile detention centers actually need high-level mental health supports. We have 30 counties in the West that have signed on to creating a PRTF. And so I think rather than changing things, we need to invest in the things that we actually need to invest in. Human Services talks a lot about wraparound service supports for our kids. And what we know is that when we don't invest in those high-level mental health needs, we're not talking like daily therapy. We're talking actually living in a facility, getting the ongoing supports that you need. And what we hear from adults is that often the kids who have behavior outbursts really need mental health supports. I also want to highlight just the entanglement of the juvenile detention centers and how that impacts us as adults. Right now we know that there's some areas in the parole board that actually, when it looks at sentencing, we look at the juvenile record, which I don't believe is fair. And I think there's a lot of data that the Department of Corrections will provide us to show the direct linkage to when we over-incarcerate young kids, there is an impact in the adults that we have in Minnesota. And so I would just continue to support a no vote on this and do the work that we need around wraparound services, holistic supports for our children. We'll be done.
I recognize a member from Candy, Ojai, Representative Baker.
And thank you, Mr. Speaker and members. I rise to support the Duran amendment today. Our counties need more tools for these young children that have created some real challenges with harm. We need to give them more tools in their toolbox to make sure they put them in a place where they can be more safe. We have better places to house them. Again, I appreciate this amendment. I do not sit on this committee, this public safety, but this is critical that our hearing from our county justice folks. So please, I urge you today to support the A3 amendment today for Representative Duran. This is important. Our counties are asking for it. This is where we've got to give them some more support until we get all of the services in place. Thank you, Mr. Speaker.
Any further discussion of the amendment? I recognize the member from Washington, Representative Johnson W.
Thank you, Mr. Speaker. Just wanted to bring up a letter that I received from the Washington County attorney regarding this. And he says, before these provisions take effect on August 1st, Minnesota must address critical gaps in companion statutes, including child maltreatment reporting and response framework under Minnesota Statute Chapter 260E, and must create clear, workable alternatives that give law enforcement, social workers, schools, and county attorneys meaningful options when responding to offending dangerous behavior by children under 13. They are not saying change it. They are saying they need more time. The people who are going to be implementing this and taking care of this with the children are not ready. It's just not ready yet, and there needs to be more time. So please vote yes on this amendment. It's going to benefit everybody. Thank you.
Any further discussion to the amendment? I recognize the author of the amendment, the member from Beltrami, Representative Duran.
Thank you, Mr. Speaker. I understand the hesitation in the change of this law. But when you have this many people, the people that are dealing with this every single day, coming to us, begging us to not do this because it is going to put them in a hard place, I think we need to slow down a little bit. We say listen to the experts. Listen to the people. We are not doing that right now. We need to understand that the people that are sitting here asking for us to make a change in this law, not to completely repeal it, to give some time in order for them to make the foundation to be successful in the change that we are trying to implement. There has been efforts by these people to work with people in the legislation for a delay because we're not ready right now in the state of Minnesota. But it has fallen on deaf ears. What are we telling the agencies? JJAC. What are we telling JJAC? We set up this as a legislation, and we are completely ignoring them. What are we telling our tribal partners? They're asking us to support them right now. We'll ignore it. We won't listen to it. But I'm fine going back to my community and saying that I tried. The thing is that we are failing every single person that's getting in these lists right now, that is in this list. Every single agency is going to be hurt by the actions that we don't take today. And we're okay with that? Are we supposed to support our law enforcement, social services, county attorneys? Are we the body that turn our backs on those groups? What are we doing here, guys? The problem is that you can ignore me now, but you cannot ignore the constituents that are going to be knocking on your doors here pretty soon, wondering, what did we do? This is going to have a drastic impact on the state of Minnesota. You guys already have the list of the people. I'm just concerned right now that we're going to have a 12-year-old person, a kid, a child, stab somebody, rob somebody, and we're not going to have a place to put that person because it's no longer a criminal offense. If you don't trust me, get on your little phone right now and call your attorneys and ask. You can put them on a CHIPS hold, but guess where they're going? To one of the maybe 5 non-secure facilities that we have. Otherwise, they're going back home. Or you're going to stick one of those violent offenders with someone who's actually trying to get help in some of these areas. A vulnerable child at this point in time, you want to put a more aggressive child in with them? Are we setting them up for success? I'm a little concerned right now that we hear all the time that we're here for Minnesota, but we're turning our backs on our juveniles.
Seeing no further discussion, the clerk will take the roll. Members, please vote. The chief clerk will call the names of the members voting remotely.
Green.
Green, no.
Green votes no. McDonald.
McDonald, yes. Aye.
McDonald votes aye. Momani Hiltzley.
Call the names of the members. Mamanya Hiltzley, no.
Momani Hiltzley votes no. Perez Vega.
Perez Vega, no.
Perez Vega votes no.
The clerk will close the roll. There being 66 yeas and 67 nays, the motion does not pass. The amendment is not adopted. There's an amendment at the desk. The chief clerk will report the amendment.
Duran moves to amend Senate File Number 4760, the second engrossment. As amended, the amendment is coded A2.
I recognize the author of the amendment, the member from Beltrami, Representative Duran.
Thank you, Mr. Speaker. Well, since that one failed, I'm assuming we're going to go down the same track here. So this amendment is a carve-out for actually crimes of violence for this age group. If we don't want to push it out farther, then let's actually specifically narrow it to particular crimes of violence that we can actually charge these kids and hold them accountable. And I request a roll call.
Seeing 15 hands, there will be a roll call. Any further discussion? I recognize the member from Ramsey, Representative Feist.
Thank you, Mr. Speaker. I rise again to encourage members to vote no. As I said before, there are significant issues with our juvenile justice and child welfare systems. This amendment not only does not address them, it exacerbates them. And I do want to respond a bit to Representative Duran regarding the stakeholder engagement. Stakeholders were fully engaged in 2021 when we first passed this bill off the House floor with no delay. Because none was requested. Again, stakeholders were fully engaged in 2024, where at the request of author Representative Pinto, a delay was put in place. But that was not something that stakeholders requested at the time. There have been numerous meetings over the past year. No one has been completely ignored, and I think it's just important to set that record straight. This is an important issue, and we all take it very seriously. This provision would undermine public safety. Everyone can agree that children who pose a serious risk to themselves or others need intervention, but this can't happen through the delinquency system. Under constitutional due process rights, any person charged has to be competent to stand trial, and if they are not, the criminal charges can't go forward. This does not change based on the level of the charge or the type of behavior. If the court-ordered interventions are necessary for this age group, it has to be through CHIPS. Trying to keep this group in delinquency court will only delay the ability to put intervention in place in the scenarios where timely intervention is most critical. For these reasons, I urge members to vote no on this amendment that would backtrack on our commitment to refrain from criminalizing elementary school children. Thank you.
Further discussion to the amendment? I recognize the author of the amendment, the member from Beltrami, Representative Duran. I recognize the member from Ramsey, Representative Moeller.
Thank you, Mr. Speaker. And I found it interesting, too, with some of the comments on the last one about listen to the experts. Well, we do have experts in the letter that Representative Feist shared with the committee. We have those experts and those stakeholders. You also mentioned, are we the body to turn our backs on law enforcement and listen to the stakeholders who deal with this on a daily basis. I do hope when we discuss the extreme risk protection orders, you'll take a look at the letter from the chiefs of police. But that being said, I just want to emphasize again that we do have expert stakeholders. There has been time to get these systems in place. And neither of the amendments that we're discussing today have been vetted in committee. And again, recommend a no vote. Thanks.
Any further discussion? I'll scan the room like I do. Seeing none, I recognize the author of the amendment, the member from Beltrami, Representative Duran.
Thank you, Mr. Speaker. And there was concerns with this, even by the bill author, has actually acknowledged the fact that there was concerns with this. That's why there was an extension. But the problem is that there was no real centralized location to be able to feed these places the concerns. So when this bill was actually implemented, the DCYF that you guys created at the same time, the one that was supposed to be the centralized hub for this type of information, didn't get started until June of 2025. Then there was some turnover within inside the state. So we're not talking about 2 years to be able to work and try to figure this out because there was no infrastructure set up to get this information to the stakeholders. We completely just bulldozed this through without allowing the infrastructure to actually get in place to work this out. So there was technically 3 or 6 months for us to be able to try to gather as much information as possible to help with this. So it wasn't a long time for us to be able to figure this out. It was a short amount of time, and they're coming to the table now that everything is set in place to ask us for a simple change to help them out a little bit. But it doesn't look like we have the appetite for that. Thank you.
There being no further discussion, the clerk will take the roll. Members, please vote. The clerk will call the names of the members voting remotely.
Green.
What's the vote? Oh. Yes.
Green, no.
Green votes no. McDonald.
McDonald, yes.
McDonald votes aye. Momani Hildsley.
Momani Hildsley, no.
Momani Hildsley votes no. Perez Vega.
Perez Vega, no.
Perez Vega votes no.
The clerk will close the roll. There being 67 yeas and 67 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The chief clerk will report the amendment.
Greenman moves to amend Senate File number 4760, the second engrossment as amended. The amendment is coded A12.
I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Speaker, and that is my motion. This bill, this language bans the hosting, operating, and advertising on prediction markets. This is a really good bipartisan bill that passed out of public safety, was heard in commerce with bipartisan support, and just passed off the Senate floor this morning with 56 votes in favor and only 10 against. It's a really important policy that includes protecting our young people, our communities, and our public decision-making from the shadowy gambling markets that we've seen explode in recent months. And it's critical we act this year. As we have seen this explosion just in the under a year, you can now bet on almost anything. And all of the regulations and safeguards that Minnesota and states around the country have been putting in for years don't apply. This bill uses long recognized authority of state and tribal and local leaders to regulate gambling in our state. It prohibits unregulated, shadowy prediction markets and preserves our carefully crafted rules and safeguards around what gambling is, and it governs legal gambling at racetracks, at casinos, and charities. All of that is preserved. What this does is deal with these shadowy prediction markets. But for folks who weren't in commerce or for folks who weren't in public safety, or maybe haven't been paying a lot of attention on the internet, let me tell you what these prediction markets are. They are gambling platforms that circumvent state regulations and allow people to bet on the outcomes of future events. They're markets operated by companies like Kalshi, Fanatics, Crypto.com, FanDuel, all operating in Minnesota right now, setting up binary contracts that people can bet and get paid based on the outcome of that bet. They allow users to anonymously bet on events and almost anything. This morning I checked Kalshi. You could bet on, will FISA be reauthorized? Will Ghislaine Maxwell be released from government custody? Will Airbnb say home sharing during their next earnings calls? Or literally any sports event. And that's thousands of more things. Kalshi in Arabic literally means anything. You can bet on anything and everything. Those platforms make money by charging bettors for bringing users together, and most of these platforms also operate clearinghouses to settle the bets and participate in betting with their so-called trading arms. As I said, this has amounted to an explosion of gambling in the last year, with the safeguards that we have, age verification and others, currently not in place. In Minnesota and states around the country, we have worked hard over decades to have a regulated gambling infrastructure with effective and transparent systems to license and regulate gambling. And since I have been in the legislature, there has been a robust conversation about whether or not we should allow consumer, I thought I heard some prediction markets over here, heading out the door, as we should do with this bill. We have been allowing, we have provisions in statute that have consumer protections, that require age verification, that protect minors, and have money laundering provisions. None of those apply right now. And that's why advocates and members across the political spectrum and across the spectrum of the issue of sports betting in Minnesota support this bill. Minnesota Family Council and MIGA, the Metawakaton and Sioux community, and the Minnesota Catholic Conference, the Joint Religious Legislative Coalition, and others. Because I think we all agree that whether or not you are for expanding regulating or not, or expanding gambling or not, Minnesota should make that decision, and we should decide how it happens here, like we have since the founding of our states. Without these protections, there's no 21-year-old age restriction, no money laundering protections, and no effort to deal with problem gambling. And as the Wall Street Journal reported, it's leading to a disturbing trend of teenage gambling. Gambling experts are actually quite concerned about particularly these prediction markets pulling in young gamblers and targeting teenagers. In addition to skirting our laws, these gambling markets are rife with shadowy self-dealing that threatens to corrupt sports, politics, and policymaking. You probably all heard that at the waning days of the Biden administration, there's currently officials who are betting on pardons. There was a special ops officer who just was caught betting on the Maduro raid. We are seeing reports like this every day. And this threatens to undermine the trust that people have in us, in our system, and in our decision making. So when we talk about what we can do here, this is a simple bill. It is a bill that defines prediction markets as a system that allows consumers to place wagers on future outcomes of a specified event that is not determined or affected by the performance of the parties or the contracts. And then it includes a list: sports, games and dice, war, natural emergencies, elections, legal actions, popular culture, death, assassinations, and the weather. It makes it a felony to create, host, and operate a prediction market, or to sell or advertise or market prediction markets. It focuses on the people providing these, and it requires it to be intentional. So it does not focus on the people participating, it focuses on the market. It creates safeguards, and it includes an exemption to preserve the current framework for legal gambling and the other kinds of future contracts that are currently regulated in Minnesota. And this isn't an abstract issue. We saw last week that a member of the Minnesota legislature was betting on their own election. This came right to Minnesota last week. It is time we act. This is a good bill with bipartisan support. It passed the Senate. And members, I think that this is the moment to do it. And with that, I'd rest the roll call.
Point of order, Mr. Speaker.
Roll call will be provided. State your point of order.
Under Rule 4.03, an amendment may not increase the cost above the limit set in our budget resolution. This amendment creates a felony and has been ruled on many times before on this House floor on public safety bills, as creating a felony does indeed have a cost. So this will add a cost. It is not a no-cost amendment, and I would ask that this point of order be well taken.
Advice. I recognize a member from Hennepin, Representative Greenman.
Thank you, Mr. Chair. It is my understanding there is no fiscal note or there is no fiscal cost, and it just passed off the Senate floor.
Further advice, I recognize the member from Anoka, Representative Niska.
Thank you, Mr. Speaker. I think Representative Greenman is referring to a fiscal note that has been issued on this. The problem with the fiscal note, in addition to it being questionable for the reasons Representative West has noted, this creates a felony. Someone's going to have to enforce the felony. The fiscal note basically just says everybody's going to absorb it. That's pretty questionable. But there's an even more glaring deficiency in the fiscal note, which is that it has absolutely nothing about the lawsuit that the state of Minnesota would face. Representative Greenman referenced a whole bunch of companies that are engaged in this. It's very likely they will all sue the state of Minnesota. But what is absolutely guaranteed and what is not mentioned whatsoever in the fiscal note, both in the Senate fiscal note or in the House fiscal note, is the fact that the U.S. Commodity Future Trading Commission believes that they have exclusive jurisdiction over the types of option contracts that are being regulated by this bill. Not only do they believe that they have the absolute jurisdiction over it, they have been suing states. They sued 5 states in the month of April that is not referenced in the fiscal note. They sued the state of Arizona. They sued the state of Connecticut. They sued the state of Illinois. They sued the state of New York. And they sued the state of Wisconsin, all in the state of April, all in the month of April. So if we pass this, we are guaranteed buying at least one lawsuit, probably multiple lawsuits that the state of Minnesota will have to defend. This clearly creates a cost upon the state of Minnesota beyond that laid out in the budget resolution, and it will, for that reason, Mr. Speaker, I urge you to find the point of order to be well taken.
I recognize the member from Ramsey, Representative Moeller.
Thank you, Mr. Speaker. Well, I will encourage you to find the point of order not well taken. I've got the fiscal note up right in front of me. It does have 0 cost. Something that Leader Niska just said was that it creates a felony, so it automatically creates a cost. That is not true. Lower level felonies, if it doesn't say it's lower level felony, often doesn't have a cost to the Department of Corrections because those are typically probationary sentences. And also there are cases where those costs are absorbed if they're very low level. And so I think it sets a very bad precedent in this body if we are going to say that this is out of order because it has a cost when the fiscal note tells us there is no cost. Thank you, Mr. Speaker.
I recognize the member from Hennepin, Representative Long.
Thank you, Mr. Speaker. I also ask that you find the point of order not well taken. We have never applied a standard that somebody who might sue us in the future leads to a fiscal impact for us. If that was a standard, how could we pass anything? There is the possibility for a lawsuit on any bill that we pass at any time that is not something that is examined in fiscal notes, it is not relevant to fiscal notes, and it is not relevant to a 4.03 decision on the floor. And as was pointed out, what is relevant is the actual cost that has been examined here, and that cost is 0. There is a $0 fiscal note. So how you can find that this has a fiscal impact when we have a fiscal note that says $0 is beyond me. So, Mr. Speaker, I hope that you find the point of order not well taken.
Further advice. Representative Niska.
Thank you, Mr. Speaker. We frequently recognize especially likely lawsuits in fiscal notes, fiscal impact. The state Attorney General's office or somebody is going to have to defend the lawsuit that's coming. Again, the fiscal note has been referenced, but the fiscal note, every single piece of the fiscal note was completed before the month of April. In the month of April, the U.S. federal government has sued several states over similar laws. They certainly will sue the state of Minnesota over this law. The fiscal note is simply out of date, and the point of order is well taken.
Further advice, I recognize the member from Morrison, Representative Schultz.
Thank you, Mr. Speaker. To this point, I agree with Representative West. I believe that you should find this point of order well taken. And I'll just say, Mr. Speaker, to this point that's been raised by Democratic colleagues today, Mr. Speaker, they are mentioning a bill with a fiscal note that frankly doesn't even match the amendment before us. It cites another section of law in the bill that there is a fiscal note for, so it's not a good match. I listened to members in committee all session long talk about fiscal notes not being the correct match, and Mr. Speaker, it's quite clear that their fiscal note that they continue to reference as their reason for you to rule on this point of order, frankly, they're out of order.
Members, I've studied the amendment, I have reviewed the bill, I've considered all of your advice, and I am ruling that the point of order is not well taken. Further discussion to the Greenman Amendment. Seeing none, the clerk will take the roll. Members, please vote. The clerk will call the names of the members voting remotely.
Green.
Green votes yes.
Green votes aye. McDonald.
McDonald, no.
McDonald votes no. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Go ahead.
Perez Vega, yes.
Perez Vega votes aye.
The clerk will close the roll. There being 72 yeas and 59 nays, the motion prevails. The amendment is adopted. There are amendments at the desk. The chief clerk will report the amendment.
Frazier moves to amend Senate File Number 4760, the second engrossment as amended. The amendment is coded A9.
I recognize the member from Hennepin, Representative Frazier.
Thank you, Mr. Chair. This amendment would essentially add the modifications that we have done for updates to our extreme risk protection order. Members, as a body, we should be proud of what we did when we passed the extreme risk protection order. I do understand that we passed this and not everyone voted for this law, but what I can tell you is that it has had a positive impact around the state. It has saved lives around the state. The extreme risk protection order allows for when an individual is deemed a threat to themselves or others, and they have access to firearms, it allows for someone to file a petition to remove that firearm from the individual. There's extreme due process within this. It goes directly to the courts. The courts makes that determination. The individual will have the ability to appeal that, but once the court makes that determination, then a petition is executed, and law enforcement will then go and remove those firearms, or the individual can submit the firearms themselves over to their local law enforcement or to an arms dealer. This amendment, which passed through 2 committees unanimously, bipartisan in a bipartisan way, would just update some issues within this statute based on practitioners. It updates situations such as allowing for an individual to petition directly for themselves to have an extreme risk protection order, because we learned that there were individuals that wanted to do that. It clarifies that anyone from a police department can make a petition themselves and not just the chief law enforcement officer. It also clarifies that in county attorney offices, anyone from those offices can make those petitions. Members, I'm just going to give you some numbers before I move on here, but since this law has been in effect in the first year and a half, 280 individuals who were found to pose a significant risk, petitions were ordered for those individuals, and we're talking about situations that involved credible threats to schools and daycares. We're talking about individuals that were discussing workplace violence or confrontations with law enforcement. Put in short, this law saved lives, and it will continue to save lives. The updates that we're asking to put into effect going into the new year would save more lives, because we're making modifications that practitioners have told us could create barriers that prevent from saving more lives. This is a good amendment. And I do understand we tried to bring this amendment to the floor to calendar it for a direct vote. I was told that there's still some conversation that need to be had by some of my GOP colleagues. So what I am saying by bringing this amendment to my GOP colleagues, it is okay to vote for something that will save lives. We've had many debates about gun safety in this chamber. This is something that we all can vote for, and we could put in effect, make it stronger, and save more lives. We can show the rest of the state that we all agree that when we do something, when we put our minds to it, and we use our election certificates, that we can save lives when it comes to gun violence. This amendment would do exactly that. I do understand that this will be challenged and likely ruled procedurally out of order. So with that, I wanted to share what this law has done, what it will continue to do, but that we can absolutely make it better. But with that, I will withdraw my motion.
Representative Frazier withdraws his amendment. There are no further amendments at the desk. The chief clerk will give the bill its 3rd reading.
3rd reading, Senate File Number 4760, as amended.
3rd reading. Discussion to the bill as amended. I recognize the member from Ramsey, Representative Moeller.
Just again recommend a yes vote. Thanks again, Chair Novotny.
I recognize the member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker, and just to thank Chair Moeller and our staff that helped put us together. We probably will have one more bill that we will bring to the floor, so we'll do our thank yous extensively at that point. Just point out, there's nothing in this bill that was horse traded. These are all bills that we both supported and has had widespread support from bipartisan bills. I appreciate a green vote.
Seeing no further discussion, the clerk will take the roll. Can we switch? The clerk will call the names of the members voting remotely.
Green.
Green votes yes.
Green votes aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 116 yeas and 16 nays, the bill is passed as amended and its title agreed to.